everyone to Commissioner's Court, and as always, before we get started, we have Dr. Tony Romans with us to lead us in our invocation. And Commissioner McCann, would you follow with the pledges, please?
Holy Father, we love you because you first loved us. To love you and to be loved by you is truly our greatest honor. Isaiah prophesied one day the king would reign in righteousness, but Lord, until that day you have ordained government to accomplish your purpose and plan. So Father, we come today to pray for your favor, your blessing to be added to the training, the expertise of our judge and our commissioners. Father, we pray for your wisdom to guide and lead in all that's done. Father, remember today our first responders. We pray, Father, for your favor and blessing on them, that you would protect them, you'd be their fore and rear guard. And God, that truly you'd bless our country, that we would turn to you with all our heart, that it might be true of us. Blessed is the nation whose God is the Lord. In Jesus' name we ask it. Amen.
Amen.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Honor the Texas flag. I pledge allegiance to thee, Texas, one state, under God, one and indivisible.
Dr. Romans, thank you, sir. Well, the time is 9:02. We will call this meeting of Commissioners Court to order. Are there any citizens' comments?
No, sir.
There are no court announcements to make at this time, so we'll move to item 1, which is consider and take action on minutes of previously held meeting of Commissioners Court on August 19, 2025. Are there any additions, deletions, or comments?
Hearing none, Judge, I move we approve the Commissioners Court minute for regular session August 19, 2025 as presented.
I'll second his motion.
Motion made by Commissioner Tooley and second by Commissioner Spivey to approve the minutes of August the 19th, 2025 as presented. All those in favor of the motion? Passes unanimously. Item number 2 is consider and take action on a resolution authorizing county grant to Meals on Wheels East Texas for program year 2026. Court, this is a action we take every year in association with the Texas Department of Agriculture's Texans Feeding Texans, and it's the home delivery meal grant program. This is where Meals on Wheels gets the majority of their funding from. By adopting this resolution, that program continues to be made available here in Henderson County, along with the funding that the county itself provides. But this is the bulk of the Meals on Wheels funding, the backbone of it coming from the Texas Department of Agriculture that we need to take action on. Any questions?
How many years? What year did this start? Meals on Wheels.
This particular incarnation has been about 15 years.
15 years.
Maybe a little longer than that. Any other questions or comments? Entertain a motion with the judge's authorization.
So moved to approve with the judge's authorization to sign.
I'll second the motion.
Motion made by Commissioner Richardson and seconded by Commissioner McCann to approve the resolution authorizing the county grant program year 2026 for Meals on Wheels with the county judge's authorization to sign. Any further discussion? All those in favor? Passes unanimous. Item number 3, consider and take action to draw on the Lake Towns at Lake Palestine's letter of credit. Ms. Strong?
Good morning, Court. So we are here on item number 3 on the agenda, the consider and take action to draw on the Lake Towns at Lake Palestine letter of credit. Just a little bit of factual background. If this court remembers, last summer in July of 2024, this court considered the Lake Towns at Lake Palestine plat. During that time, this court disapproved that plat for lack of bonds. And the reason for those bonds was to ensure the performance of the construction of roads, streets, storm drainage, and utility infrastructure within this fairly large plat. So at that time in July, it was disapproved. The developer came back in September of last year and had secured a construction performance bond for the infrastructure, drainage, and storm canals, and separately a letter of credit for the roads and streets. At that time, and that was in September, get my dates right, September 17th of last year. And at that time, this court did approve the plat conditioned on the construction bond and the letter of credit. The letter of credit was in the amount of 1.7 million, and I'm rounding. There's some further numbers in there. And so at that time, part of the agreement with the developer was a one-year construction period. Because of the timing of the letter of credit, how it was obtained, it expires on September 9th of this year, and the construction expires on September 17th. So that's a difference of about 8 days. And so the letter of credit expires before the breach can happen. If you look at the Texas Uniform Commercial Code, an anticipatory breach can be treated the same as a breach. So if you don't think that performance is going to happen, there's a repudiation of what can happen. And so at that time, you can treat a anticipatory repudiation as a breach of a contract. And so this is a rather large subdivision. We have a fact witness that's here today. She can testify, but Ms. Kimbrough has been out very recently, and according to her, witnessed zero construction of any streets or roads out there. And so they'd have a couple of weeks to get that done. That doesn't look like it's going to happen. So this court really has 4 options today. One option is do nothing. You can just do nothing, not go forward with the revocation against the letter of credit. If you chose to do that, you could then at a later time choose to sue a lawsuit. So under the Uniform Commercial Code, you have a 1-year statute of limitations either after the breach or after the expiration, whichever is later. So that would give this court 1 year to pursue a lawsuit. You don't have to do that. So you could do nothing today and then do nothing in the future. Another option is what's presented to you today, is you can take recourse against the letter of credit. So you can go ahead and issue this letter of credit through a site draft, issue to the bank, and then have that money transferred over. If the court chooses to do that, you could put that then in a trust account or some kind of account where you hold that money, and then you could wait till the actual breach. And we're under the old subdivision rules. Under the old subdivision rules, there's a 60-day cure period for the defect after the breach. So after the county's designated engineer goes out there. So we transfer the money, it sits, you then wait till mid-September, engineer goes out, he inspects what's been done and hasn't been done. At that point, he would issue a letter, and there would be 60 days to cure that defect. If that's not done, then the county could use that money and try to get these roads and streets constructed. Another option is, like I said earlier, through lawsuit. And during the lawsuit period, you could either do it through a settlement or through a judgment if it's contested. So I don't have a crystal ball. I can't tell you what will happen in the future. I don't know if lawsuits will be involved or not, but if you take recourse against this letter of credit, it at least gives the county options then to have that money. So.
Commissioner?
Yes, this has been an ongoing thing, and the investor that's doing this hasn't reached out to us at all on it. I've talked to a third-party person out there, and actually they're in a lawsuit with the developer right now as we speak, and they haven't given us any information whether they've settled, because I think they still owe money on land. And the biggest issue is legislator passed a law in 19 and legislation of 19 that we don't do preliminary plats anymore. We go straight to a final plat, approve it, get deeds to lots, and they can immediately sell lots without having any infrastructure in there, as long as it's passed and they got the money bonded and stuff. So that's what the bond money's for. If they don't go in there and complete what they're supposed to do, we're supposed to be allowed to get it, which we'll have to go out. The county doesn't have the means of going there and building all new roads and stuff. We repair roads and upgrade roads. We don't build new roads. So we'd have to go out for bids on it to get it done. And it would be a process, but like I say, there is lots. It's already been sold to people in there. So, my suggestion would be to get the money in hand to the county and stuff, to have some comfort there that this is going to get completed and stuff. And I'm sure whoever the cash funds is put up for, the bank that gives it to us, they'll deal with the other end of it on getting their money back. So, but I'm for myself going after the money and getting it in the county's hand. That way, if we got to pursue of getting go out for bids, or maybe the contractor that bid it the first time still may honor the original bid. That's something we'll have to check with and see. So, but I've been out there and drove around it. I took Commissioner McHam out there with me and stuff, and all they got is pathways cleared. All the wood's cleared out. There's a little bit of silt fence and stuff up, and no roads or base or construction's been done in there. So, but we get calls, every 2 or 3 weeks on people that's bought lots asking if what's going on. They don't know anything either. So, but as far as I know, we're the first one that's run into this. I put it on listserv and asked Jim Allison about it, and he said that we'd have to pursue and may have to get outside legal assistance or attorney or something that handle that kind of stuff. So, but I'd say that we go through and procedure and stuff and go for it and get the money instead of lawsuit if we're able to get the money, and because that should be enough. And then I think the other security bond, there's a security bond, it's still good for another year, and that's for drainage and water. I think drainage and water that procures it. So,
Commissioners, questions?
So if we go out for this money, does that then make the county responsible for the road?
No. Are you talking about like county maintenance?
I'm just talking about do we have to finish the roads?
I think it would be for the county if we had that money. So how we do that, I don't know. We could go out for bid.
Because then I'm thinking we got to go out for bid. Ms. Mom, do we have to go out for bid?
Yeah.
$1.7 million bill.
Yeah.
Even if the company says that they will honor their bid, that bid wasn't to us, so does it count? So we have to go out for engineering?
even though it's not taxpayers'
So
money.
we have to re-engineer.
I don't think that that's going to matter in this situation.
Yeah.
We have to re-engineer, we have to re-bid. We know what that costs for government. So I don't think 1.7 million is even gonna touch this road. Then we got to build the road. So what happens when we run out of the 1.7 million?
So there's an attorney general opinion, and it's just an opinion. There's no case law or anything on this subject. The attorney general did point out that the commissioners have the ability to do this through this statute under 232 of the local government code, but there's no guidance on how it's implemented. So it's, you all figure it out. So here's your power, but good luck implementing it. There's no guidance within the statute of how to do it. According to the attorney general, they believe that any incidental benefit higher than that amount used is okay to use. So if it was over 1.7, the attorney general believes you can go over.
With whose money?
Taxpayer money.
Or can you just quit? Can you just quit at the 1.7?
There's no guidance.
But if you don't quit, then you have to use our road and bridge funds, which is taxpayer money.
Our concern would be if we went out, we secured the letter of credit, we secured the bond. if we do nothing and we say, well, we don't want to be on the hook for it, you could end up being on the hook for it anyway. So I think there's risk to the county. Either way you go, we're choosing and recommending the option that puts $1.7 million in our hand with the exact same risk.
Can the people who bought lots out there, since we approved the plan, can the people who bought the lots out there sue the county?
And let's, first of all, they are actually also suing the developers in litigation. And so, yes, our concern would be, as Mr. Strong said, there's no precedent for any of this. I think all of this is a direct result of the new laws that were passed in 19 that allowed this to happen. So we don't have any guidance or precedent on it, but that would be the argument, yes, Commissioner, is if we do nothing and show that we aren't even going to try to enforce the letter of credit or the bond, because if you're one of those individuals, what you're going to come back and say, well, wait a minute, you secured all of this through a letter of credit and bond, and then y'all turn around and didn't even, we're the only ones that can go after the letter of credit. We're the only ones that can go after the bond. And then again, my fear would be those owners would say, well, y'all just can't sit there and do nothing and let the developer get away with not doing the development. The developers, best we understand, they probably sold $12 million worth of lots, collected the money, and then they're gone. And again, under the traditional ways we would have done developments before the legislature capped our ability to regulate them, we would have said, this is exactly why traditionally we have not liked pre-sales, we have not allowed pre-sales, because you have a developer that has an idea, they come in, they pre-sell the lots, they take the money, and then when it all falls apart, we're left to put it back together. This is exactly the position we're in now. That's exactly essentially what happened here. They pre-sold all the lots. And so our concern would be by taking that approach, and that is an approach you could take and say, hey, we're not. You still may have some risk that you would have the actual property owners that now own the lots in there come after for failing to do our responsibility. And again, there's no guidance or precedent one way or another on that. That's something that would have to go to a court for a case of first impression.
I'm just worried that we're gonna get the $1.7 million and then we're gonna be, that $1.7 million is to finish the roads. And then we get our bids in and our engineering in and it's 4.2 million. A lot of roads down there.
Which engineering's being done, it's been done on it already, the engineering stuff.
For us though, does it have to be for us?
I don't know.
I mean, that's gonna be something we'll have to research.
I mean, it's been engineered, but we didn't go out for the engineering.
And if it's gonna cause taxpayer dollars eventually, which we know it is, I suspect there's gonna have to be some bidding done in on it.
I completely agree, we would have to have the bid. I would believe we could use the previous engineering. That's not something we've looked at, so I'm speaking completely off the cuff. I think we could use the engineer and build it to the engineered principles that the engineering's already been done.
And that's due to the fact that our contract engineer signed off on that original. That would make that somewhat applicable to us being able to use.
You see, that's the question I had when they first came in with the road bid. It was $1 million higher than what they bonded. They come in with a second bid from a different company, and like I say, it was $1 million less. So I asked the engineer, is that going to cover what they're doing? And he said yes. So.
Well, you can lay this, and I'm going to get on my soapbox, you can lay this at the feet of the Texas legislature.
They designed this to...
Prior to 2019, we required a preliminary plat that had everything laid out. The construction had to be in place. Everything had to be finished before we could give them a final plat, or would give them one. And then and only then could they sell lots. The Texas legislature has returned development to the 1970s. I believe that with all of my heart. Henderson County, or let me put it this way, Cedar Creek Lake and Lake Tawakoni Development of the 60s and 70s taught Texas how not to develop. And as counties got more and more where they were doing this, the developers got more and more upset with us. We had one meeting, not on this one, but the one prior, where the developer and the engineer said, we're going to go talk to our representative about this. Y'all can't do this. We told them and we told them. So now, guess what? We get to clean up the mess. Or shall I say the taxpayers get to clean up the mess. Local control is very important. And the legislature doesn't want to hear from local control, about local control, only when it's convenient. So I'll get off my soapbox, because this was completely preventable. So, anyway.
Everybody's made good points this morning.
And we've had two of them. We've done one in 4, and there was one done in 1, and they went smoothly. They worked out okay, but there'll always be that one. It's always going to happen. And it took our third one to come in to find out, and we got one
In this
we're
court,
supposed to.
we had this discussion last summer, and that was why it was disapproved initially. And we were talking about the detriment of pre-sales, which the property code does allow. And we only had 30 days to do this under that new statute. So.
Developers are not friends to the taxpayer. So,
And another thing, like I said, we've got 30 days to bring it to order, approve or disapprove. If we don't, it automatically goes. But I think they still, to be automatic, they still have to have all their bonds and stuff in place and everything. It wouldn't ever approve without a bond, because it has to be.
Well, it's a
If we
conditional.
don't take it to court, it automatically approves.
Without the bonds.
Without the bond.
exactly.
So,
If we do not take action to scrutinize it to the full extent of the law, we're cut out.
Yep.
That was another thing they put in there. Oh, in this last session, sorry,
Kinda
this
lower the
last
days, don't they?
session, they tried to pass a point where a third-party review would cut us out completely. So it didn't even have to be sent to us. Luckily, that failed. You know,
Well, they're still in session.
the governor can put anything on the call, that is for sure.
I know they only sold a handful of lots, didn't they, 20?
Is it 30 or 40?
And it was still 10 or 12 million dollars. I mean, it's
More than 20.
a very, the lots are expensive.
And there was some previous litigation. There were about, like I said, I won't say the number was in the 30s.
There's been previous litigation between a lien holder and the developers that actually blocked, they had about 12, a dozen, I want to say, closings that were set that actually did not take place. And I'm sure those buyers are thankful today because litigation started between the financer and the developers before some of those. So some of those were blocked, but I think the numbers, probably around 40 would be an estimate as to how many were actually sold. It's also a lesson that, buyers beware. I mean, I think some of the legislatures would say, we can't fix that. If somebody wants to go buy and do business with a developer and give them money for a product that's not yet built, that's the risk that the individuals take for buying or not. And so it's also a lesson to the public of buyers beware. If you're buying property in an undeveloped neighborhood, just remember you may end up owning property in an undeveloped neighborhood.
But now, the other question, when we run out of the $1.7 million, can we quit?
No guidance in the statute.
No
so
guidance.
We'll have to figure that out. And
But I think we believe that we're going to take the position that we can. That this does
According-
not obligate us to complete the entire infrastructure.
Right.
I think there's an argument of detrimental reliance that these people relied upon us securing these bonds, securing these, and if we do nothing, it's to their detriment. I think we fulfill our obligation by taking the letter of credit money. If we can get the bond money, we take the bond money, and once we expend it, then I would feel comfortable, even though there's no precedent or guidance, that we've done what we can do.
and we do know that the power has been paid up front for all the electricity and stuff. Trinity Valley requires them to pay electric utilities up front, so it's been paid for in full.
And I will say this is a public record, but there is a mechanics lien as well for the clearing of that land. According to the mechanics lien, that was never paid for, so.
Do you know how much that lane is?
It's, I think it's under 40,000.
Would that be part of this 1.7 million?
Let me look at the, I have the engineering.
There is, while he's looking, there's currently still pending litigation between the lender and the developers. There's also a chance, and frankly a hope from my standpoint, that if the lender can resecure the property, then they can go back out, hopefully find a new developer that would be interested in coming in and carrying forward the development in the project. So a lot of that, again.
So could we sit on the 1.7 million until all this litigation's done?
I think we've got some time.
And wait for a possible new developer?
The issue at hand is to not let the letter
Yeah,
lapse.
right.
Expire, because if it expires, then you're left with
Yeah.
nothing. We would rather have it, pay it into the registry of the court, which is what we would propose, that it be placed
Into the registry. This is not something that I would anticipate even by the end of the year that we're gonna be rushing out
Yeah.
to get bids on. There's too much going on, too many moving parts. I think what we're trying to do is secure that money, pay it into the registry of the court, and the court can be a keeper of it. And obviously, the hope would be that if a new developer can come in, we would just turn around and assign that money out of the registry of the court by court order to the new developer and say, here's 1.7 towards the roads that we've secured.
There's a mass excavation and topsoil removal as part of the engineering, so.
Well, it is not a small subdivision, what, 287 acres, 104, or 258 acres, and 149 lots, so,
and some of the prettiest waterfront lots that you could ask for or find. I mean, these are high-end lots.
And also, according to that Attorney General opinion, should the county do go forward and have these roads built, it doesn't become part of the county maintenance. So it's not something that, just because we're part of that, doesn't mean we have to accept those roads.
Is it a gated community?
Yes.
It's supposed to be.
It was
gated.
supposed to
it
be.
was supposed to be.
Yeah. I don't know who's going to build the gate.
Public funds go into it, it won't be.
And maybe the county would want to maintain it. I don't know. That would be up to the court.
Well, if public funds are put into it, it can't be gated.
According to the Attorney General, in this scenario, it can be.
Really?
Yeah.
That flies in the face of
I
250.
don't know that they would, and again, a lot of this is the position we're taking, that these are not public funds. Again, we're securing funds from a letter of credit. Those are paid into the registry of the court. You're a probate judge, no different than you have probates where money is paid into the registry of the court. That doesn't make those public funds because they've been paid into the registry of the court. And then that would be our position here, which I think is the guidance that Mr. Strawn says out there, is that these are done. But I don't think, again, off the top, there's a lot of issues here, a lot of questions been asked. I don't think that argument would keep us from avoiding the bid laws just because it's
Right.
not public money.
Right. We could run down that rabbit hole, because if we took the money and built it ourselves, there's the argument of labor and equipment is public funds. So I would definitely stay toward the bidding side of it myself, but that's down the road.
I don't think the extent of that subdivision, I don't think we even have the equipment to build what's got to be built out there.
Yeah. I know the topography was challenging,
Yeah.
because that was when Commissioner Giesland was dealing with
And most of our equipment is for the purpose of maintaining already built roads, not for building new roads.
Commissioners, anything further in this?
My questions have been answered.
Okay. Any final thoughts, Kim?
No, everything's been covered well. Thank you, Court.
Thank you.
Thank you.
Court, we have a motion.
Well, I make a motion to go, I think we call that option 2 for securing the money, the bond.
I'll second the motion.
Motion made by Commissioner Richardson and second by Commissioner McCam to approve the order for the court order to draw on the irrevocable letter of credit by side draft approved by this court in 2004. Anything further? 2024. Sorry, 2024. Anything further? All those in favor of the motion? Passes unanimously. Thank you. Item 4, consider and discuss notification of an election order pursuant to section 775.0751C-12 of the Texas Health and Safety Code for informational purposes only from Emergency Service District Number 1, proposing the adoption and imposition of a 2% sales and use tax within the district. Court, we had one of these a few months ago, another ESD wishing to collect sales tax. This is for notification of the court that they are pursuing this option, and open to any discussion. There is no action to take. Is there any discussion? If not, then we'll move to item 5, which is consider and take action to set a proposed 2025 tax rate for the 2026 county budget. And court, you will remember we have worded that way given the funding for the 2026 budget is the 2025 taxes. We have worked on this now for a couple of months and coming down to the point where we have to propose a rate today for us to follow up and set public hearings on. For discussion,
So it's the 2025 tax rate for the 2026 budget.
correct.
Okay.
Remember, taxes are due the following year is the reasoning for that wording. Discussion?
So in number 5 or number 6 is when we need to set the tax rate, or do we need to set it in 5?
In 5 is where we
Set it.
set the
Where we
rate.
say what our proposed rate is?
Yes, sir. Yes, sir. And of course, item 6, then we set a public hearing for the public to be notified and provide them an opportunity to come discuss with us about that tax rate.
Well, I move to propose the tax rate, which is also the voter-approved rate, of .3314930.
Second.
We have a motion by Commissioner McCam, second by Commissioner Tooley, to propose the 2025 tax rate for the 2026 county budget year of a cumulative total of .3314930. Further discussion? I want to add that this, when I say the cumulative rate, that is general fund being set at .274289, road and bridge fund .017228, and farm to market and flood control at .039976. Any further discussion? All those in favor? Passes unanimously. Item number 6, consider and take action to set a public hearing for the proposed 2025 tax rate for Henderson County. The rules are that 25 days after the proposed budget is filed, you must hold the hearing. And our timeline is for September 9th. And normally we set these early up into the process, like around 9:05 or so. Thoughts, discussion? Get a motion to set the proposed tax rate public hearing for September 9th.
I'd like to make a motion to set a public hearing on proposed 2025 tax rate, September the 9th of 2025 at 9:05 a.m.
I'll second the motion.
Motion made by Commissioner Richardson, second by Commissioner McCann, to set a public hearing for the proposed 2025 tax rate for Henderson County on September 9th, 2025 at 9:05 a.m. Any further discussion? All those in favor? Passes unanimously. Item 7, consider and take action to set a public hearing for the 2026 county budget. And this should be set on the same day, if I might suggest, 9:10. Thoughts? Entertain a motion.
I'd like to
Make
make,
that motion.
I'll second.
Motion made by Commissioner Spivey and second by Commissioner Richardson to set a public hearing for the proposed 2026 county budget on September 9th at 9:10 a.m. Any further discussion? All those in favor? Passes unanimously. Item number 8, consider and take action on contract with ES&S for electronic poll book system and support services for Henderson County Elections and Voter Registration Department. Ms. Ludke or Ms. Strong, both of you.
Good morning, Court. This is a contract for electronic poll book software application systems. This vendor, ES&S, has been approved by the Texas Secretary of State as an approved vendor for election type equipment and software. This particular contract has also been approved by the state for procurement purposes under the buy board. And so this has been approved under both of those, under competitive bidding and under election certified equipment. So this agreement would be for 38 express poll books with ES&S. And this would be for the coming year. So this would be a one-year term that is renewable. And these poll books are necessary for elections.
Court, questions?
Are these, is this just actually software, or is this the,
This is the actual equipment, so it'll be 38 poll books, and then the software agreements, I believe $8,000 after that, so.
was it last year that we had to buy batteries? Was that for the poll books?
That was for the voting machines,
For the old machines?
for the voting machines.
For the voting machine
Yes, yeah,
batteries,
this is
okay, so it
different.
wasn't the poll books, because I remember we spent a lot of money on batteries, so I
Yes.
didn't know if it was, we're replacing something new that we just spent money on, so, okay, thank you.
And this will be with the same company, so everything will be matching across, will be the same vendor, so.
Our current equipment is aging, correct?
Yes.
We're looking, how old?
2019, we've added some new laptops to them. This is actually going to go from like a laptop tablet to just a tablet that's going to flip back and forth. So it'll be a lot less equipment to deliver, a lot easier on the poll workers to set up, so it should streamline it a lot easier.
Were we using the ES&S poll books prior?
No, we currently have a contract with Votech that we were using those. So we're going to switch companies.
What was the deal with, I think we discussed something about the barcode or something, is this,
No,
that's not part of it?
No, that's
No.
totally
Okay.
different. That's from the executive order, and I think that's kind of went away. I don't think that that's going to be
Gonna happen, okay.
something that we're going to have to change next year. It may come up later, but that's not going to be implemented next year. So we
Okay.
can continue using our voting equipment.
Any other questions?
Does this need your signature? The judge's signature?
Yes. Well, this, Ms. Ludke, what you and your office pull off sometimes every year, it seems like we have more and more elections, different entities and responsibilities that's been put on the elections department, specifically with the dissolution of the Cedar Creek Hospital District, having this set aside, this is really the backbone of our integrity to our system. And so we appreciate your efforts that you put into this very, very much. So, court, entertain a motion.
So moved to approve with the judge's authorization to sign.
I'll second the motion.
Motion made by Commissioner Tooley and second by Commissioner Richardson to approve the contract with ES&S for electronic poll book systems and support services for the Henderson County Elections and Voter Registration Department with the county judge's authorization to sign. Any further discussion? All those in favor? Passes unanimously.
Thank you.
Thank you. Item number 9, consider and take action on appointment of member to the Natchez and Trinity Valleys Groundwater Conservation District Board of Directors. Court, we have a vacancy in your backup to this board. We have an individual that's brought forward with, I believe they're back, Bethel Ash Water Supply Corporation.
Yes.
Commissioner, if you would, lay this out for us.
Yes, we have this position open at the Natchez and Trinity Valley Groundwater Conservation District due to a resignation. And I propose that Cody Rayburn, and Mr. Rayburn is here today. If you please stand and let everybody see who you are. Most of them probably know you. You do have a bio in your backup, but Cody's from here in Henderson County. He went to school at Athens and Trinity Valley and Tarleton State University. And right now he is the general manager of Bethel Ash Water Supply Company. And he came forward and showed interest in being on this board after I visited with him. And I believe he'd be a good addition to the board.
This position is a position that is represented by the quote-unquote industry that is laid out. And by having an individual that is a part of one of our local water supply corporations brings an insight and an interest that one would believe is in the best interest of the public using the, not only the water system, but the oversight of the aquifers as well. Court, questions, discussions? Hearing none, entertain a motion.
I'll make the motion that we appoint Cody Rayburn to the Natchez and Trinity Valleys Groundwater Conservation District.
I'll second the motion.
Motion made by Commissioner McCann and second by Commissioner Richardson to appoint Cody Rayburn as a member to the Natchez and Trinity Valleys Groundwater Conservation District Board of Directors. Any further discussion? All those in favor? Passes unanimously. Item number 10, consider and take action on the Henderson County Emergency Service District Number 7, 2024 financial statements in accordance to HB 3764 for filing purposes only. This ESD, I believe, is shared by 2 or 3 precincts, but they are underneath the 250,000 mark, so they're doing their financials and sworn statements as a part of statute. Is there any discussion? Hearing none, entertain a motion.
I'll make the motion that we accept the financials from Henderson County Emergency Service District Number 7.
Second.
Motion made by Commissioner McCam and second by Commissioner Tooley to accept the Henderson County Emergency Service District Number 7 2024 annual financial statements in accordance with HB 3764 for filing purposes only. Any further discussion? All those in favor? Passes unanimously. Item number 7 is to receive financial reports, of which we have none. Item 12 is consider and take action on payroll distributions and accounts cash sheet, of which there isn't. Item 13 is consider and take action on submitted contracts. There are none. Item 14, consider and take action on requests for right-of-way permits. No right-of-ways. Item 15 is consider and take action on submitted budget amendments. We have none of those, but we do have an item 16, which is consider and take action on payment of bills. Ms. Carpenter.
Yes, sir, we have fiscal year 2025 in the amount of $459,639.50.
Commissioner Spivey, questions?
I have no questions, Judge.
Commissioner Tooley.
Excuse me, I have none.
Commissioner McCann.
I have none.
Commissioner Richardson.
No questions, Judge.
Entertain a motion.
I'd like to make a motion to approve the fiscal year 2025 bills in the amount of $459,639.50 as presented.
I'll second his motion.
Motion made by Commissioner Richardson and second by Commissioner Spivey to approve the 2025 bills in the amount of $459,639.50 as presented. Any further discussion? All those in favor? Passes unanimously. Item 17 is consider and take action on submitted plats. At this time, we do have an addendum that was posted to the plat that we will, an addendum to the agenda, which was posted. And on that addendum, we have item 1, which is consider and take action on a site plan from the Grove Estates Tiny Home Park located in Precinct 4 for filing purposes only. Commissioner?
Yes, Court, this been an ongoing deal for a while. It's actually in the ETJ of Athens, and there was kind of discrepancy on who was going to handle the platting in the ETJ. Some of it's done by the city of Athens, and then some of it's handed over to us, and they didn't have anything on tiny home parks within their regulations and stuff, so I'm assuming it got handed over to us to do it, but they'd already started this tiny home park without any knowledge of us having to be involved in it or somebody being involved in it. So they've done this. It is completed. It is a very nice tiny home park. I took Commissioner McCam out there to look at it. It's very well built. Got asphalt roads. It's got curbs and gutters. You see in there, they've got all their septic stuff in. They've got their retention ponds. Everything's like it needs to be. The only thing that we come up on is on their lot size. On their site plan, they do have one little typo error on the lot width. It's supposed to be 50 foot per lot, and it's 15 on the site plan. So I don't know if that's something that they need to redo the site plan, or since it's not actually a plat and it's just a site plan, if that can be handwritten in, or what needs to be done on that. It's just a typo on the width of each lot. But all the meets and bounds and stuff are there in the survey.
When we created this process 3 years ago, there was much discussion about road widths, utilities, lot sizes. The plan is, my understanding, the benchmark for the development. Is it just one location that it says 15, or is it scattered throughout?
Let me blow it up right here. And I have Mr. Bob Crone. He's the representative for this Groves Estate, and he can answer that question. I'm trying to look on here. I got to blow it up. Mr. Crone, can you come up and show us on here where the typos are? Is that on each lot where it says, it says a 16-foot wide unit.
Correct.
Each unit is 16 foot wide, correct?
That's correct. Under the notes section,
It's in the notes.
typo of that lots are approximately 50 by 120, which is addressing all lots, and that on the notes it reads 15 instead of 50. So that strike and replace would be at one location under the notes.
Where it says lot size are approximately 15 by 120, it should read 50 by 120
And that's over in the notes.
in the
On
notes
the
section,
notes.
site plan notes.
Mr. Strong or Mr. Davis? This is this would be the document of record.
And we did discuss this in the development office. I thought it had been fixed, but the width of the tiny home is 16 feet. The minimum standard has to be 20, but I believe the whole thing is 50, so I think legally it's okay. It's the issue of how it should look visually, as this is an official filing. I believe that the court could use discretion to interlineate with all parties agreeing to the interlineation, but the court could also disapprove it to have that fixed if the court wanted to. But I think you could do it either way. I think you can do interlineation by agreement with the initials by the developer or the site plan submitter and the court.
I know I went by there with the commissioner, and if we have any more go in, we need to send them over there and have them look at this one.
Yeah.
It was done really nice.
That's one thing, like I say, these are all going to be homes that come, I think in their restrictions, they have to come from, what's the name of the place that builds them out here? Y'all's called the cottages. Platinum Homes. They had to come from Platinum Homes from Athens, every one of them.
It'll come directly from Recreational Resort Cottages, which is the sales location at 175.
You step up to the mic here.
175 in the loop.
Yes. That is actually indirectly related to ownership. So if you want a product, it will have to come from there, which ensures that there is a quality product there that will stand up and last and be presentable for the customer.
In the past, we have approved things as amended and could follow through if Mr. Strong is saying that with agreements, strike and initialing, especially if we have it in the motion so that there is a record even attesting to the strikes.
Correct, because this is a typo, it's not a variance, and so the number's wrong, but the actual distance is correct. So,
And I think if it'd been a plat where they were going to write deeds off this record and stuff, would make a difference, but it's just a plan, I would think, and so we could make an amendment to it just to correct it on their handwriting. So,
You know, when we wrote these, it was, the way the law was written, it had to be an infrastructure plan,
yeah.
is the way I remember the discussions going.
correct. It's part of the Chapter 232, but it kicks it out of the platting and sends it over to infrastructure, which has some of the same
Right.
requirements.
And that, just so everybody understands, on this sort of an addition, unlike a plat, these lots are not for sale.
Not for sale.
These are all owned by one individual, and you move your trailer, your tiny home in this instance. So it'd be,
Yeah. This is not a.
that's why you don't have to go through the regular plat.
And I believe there are 2 variances before the court as well. I don't know if
Yes.
those were addressed. And like Commissioner Richardson said, this really started out where we thought the city had this. That was our understanding. They didn't have the ordinances dealing with this type of development, and so the county did. As of 2021, the county already had these infrastructure rules in place, and it is in the extraterritorial jurisdiction. One of those requirements is under, get the right statute, 5.5P of our infrastructure, which does not allow for single entrance. This is a nice road. It's paved. It does have a loop. There's also an emergency exit, but it still doesn't comply with the, it has a single entrance, and so that would need a variance. And then 5.5H and J is some topo information elevation. I know Ms. Kimbrough's looked at it and understands there needs to be a variance, but she's not opposed to that a variance. So.
Any other questions? All right. Who wants to get your motion together for this one?
Do we need to, if we accept it by, with amendments, does each commissioner need to sign it?
No.
Just
It'd be in the record.
And precinct 4 sign it?
Yeah.
Okay.
So with that, entertain a motion.
I'd like to make a motion to approve the site plan for the Groves Estate Tiny Home Park with an amendment to the notes that the lot sizes are 50 by 120 instead of 15 by 120. Make the correction of 50 foot on the widths. And I'd also like to approve 2 variances. One of them is a variance for not having topography on the site plan, and the second one is only having one ingress egress for filing purposes only.
I'll second that motion.
Motion made by Commissioner Richardson and second by Commissioner McCann to approve the site plan for Grove Estates Tiny Home Park located in Precinct 4 as amended, along with the approval of the 2 variances mentioned for filing purposes only. Any further discussion? All those in favor? Passes unanimously. Thank you. Real quick, we'll jump back to the other agenda, or the main agenda, which is number 18, open and consider bids, which we have none. And now we'll go back to the addendum, sorry. And this point, it is item number 2, which is to convene into executive session pursuant to Texas Government Code Section 551.074 to discuss personnel matters involving County Fire Marshal. Court, can we have a motion to convene an executive session at the time?
I'd like to make a motion to convene an executive session at 10:10.
Second.
Motion made by Commissioner Richardson, and second by Commissioner Tooley, to convene into executive session at 10 o'clock.
10:10.
10:10, sorry. All those in favor of the motion? Passes unanimously. Thank you for being with us. We'll be back in a little bit. We have a motion to reconvene into open session.
I'd like to make a motion, move back into open session at 11:30.
I'll second the motion.
Motion made by Commissioner Richardson and second by Commissioner McCam to reconvene into open session at 11:30. All those in favor? Passes unanimously. At this point, we're considering take action on matters discussed during executive session. Are there any items to move action on?
Judge, I make a motion to terminate the appointment of the fire marshal.
I'll second.
Motion made by Commissioner Tooley, second by Commissioner Spivey to move and to terminate the current fire marshal from the position. Any further discussion? All those in favor of the motion? Passes unanimously. Are there any other items that need to be addressed?
Judge, I move that we appoint an interim fire marshal of Mitch Pate.
I'll second.
Motion made by Commissioner Tooley and second by Commissioner Spivey to appoint Mitch Pate as the interim fire marshal. Any further discussion? All those in favor? Passes unanimously. The final item is 19 on the regular agenda of consider and take action to adjourn.
So moved.
I'll second the motion.
Motion made by Commissioner Tooley, second by Commissioner Richardson to adjourn at 11:32. Any further discussion? All those in favor? Passes unanimously.